Morning. Good morning. This is Georgine Adams, the Chair of the Environmental Management Commission. I'm calling this meeting to
Muted.
need everybody to mute right now until you're requested to speak. Calling the meeting to order at 9:04. This is a continued special meeting of the Environmental Management Commission being held both in person at the Hawaii County Office of Aging at 1055 Kinoole Street in Hilo, Hawaii, and online via Zoom. This meeting is being held by interactive conference technology, Zoom, and shall be automatically recessed for up to 30 minutes to restore communication when audiovisual communication cannot be maintained with all members participating in the meeting or with the in-person location identified in today's agenda. The meeting may reconvene when either audiovisual communication is restored or audio-only communication is established after an unsuccessful attempt to restore audiovisual communication. If it's not possible to reconvene the meeting as provided within 30 minutes after an interruption to communication, the meeting will be in recess and we'll attempt to reconvene at 1 o'clock in the afternoon using the same meeting IDs listed in the agenda. If at that time a quorum of remote members and the in-person members are unable to establish and maintain at least an audio-only connection by 1:15, then the meeting shall be automatically terminated. So everybody cross your fingers. This is going to stay online. One of the things we may or may not need to do, this is just me talking, sometimes when there's too many people on visual showing their face, it slows the connection down. All the commissioners definitely need to be showing their presence, but we may have to ask guests to cut their camera. Like to introduce the commissioners that we have. I don't know if everybody sees the same lineup on their screen that I do, but I'll start in the corner with our in-person commissioner, Lee McIntosh. He represents District 6. I am Georgine Adams. I represent District 9. I'm also the chair of the commission rather. Next to me is Kara Wong, our counsel, deputy corporate counsel for the EMC, the Environmental Management Commission. Then we have Dee Fulton, commissioner for District 7. Our vice chair, Commissioner Rick Gaffney, is in the second row. And then in the third row, we have John Burns, who is commissioner for District 1. And did I miss anybody? I don't think that's the commission. And we have quorum with 5 of us to be able to do this hearing. And we'll work through some of the requirements as we move through. Just a reminder, everybody turn off your cell phones and other beeping and bopping. I will go yell at the lawnmower people if they come by to try to make sure that we can all hear each other. Next up is public testimony. We received no written testimony that I'm aware of, but if any of the public present on this call would like to give testimony on the agenda, which is the single item of the contested case hearing, please identify yourself now. Seeing no one wishing to give public testimony, I will close the public testimony. And next will be the agenda for the meeting, which is contested case hearing of Kayala Partners LLC, appeal of the Director of Environmental Management's decision to bill 2 wastewater accounts for TMK numbers 375-019-018 and 375-019-026. This contested case hearing is being held in accordance with Chapter 91 of the Hawaii Revised Statutes and Part 3 and 7 of the Environmental Management Commission Rules of Practice and Procedure. The issues involved in this case will be Kayala Partners LLC's appeal of the Department of Environmental Management Director's decision to bill 2 wastewater accounts for those TMK numbers. This hearing was set pursuant to Kayala Partners LLC appeal dated October 12th, 2021. The commission anticipates that we may convene an executive meeting regarding this contested case hearing matter pursuant to Hawaii Revised Statutes, Section 92-5A4, for the purpose of consulting with its attorney, Kira Wong, on the commission's powers, duties, privileges, immunities, and liabilities. That would require a 2/3 vote of the commissioners present at this meeting. May or may not need to go there. I would like at this time to have each party or their legal representative state their name for the record. If we could have the Kayala Partners identify themselves for the record.
Good morning, Commissioner. This is Richie Henderson, representing Kayala Partners LLC. With me today is my father, Richard Henderson, and our guest, iPad 4, Rich Peterson.
Okay. And then we have for DEM.
Good morning, commissioners. I am Deputy Corporation Counsel Malia Kekai, representing the Department of Environmental Management. Actually, the Director Ramsey Mansour was also here. We also have the other witnesses are Antoinette or Tony Nakatani, the inspector, and that inspector of property, and Robin Bauman, business manager.
Okay. I guess, I don't know if I should ask now or maybe later whether Mr. Peterson will be testifying or participating in this meeting as a representative. Rich?
No, Commissioner, he is observing.
Okay. Thank you. Got some housekeeping matters to go through. One thing is I will make some noise maybe on my phone, although I'm trying to make it quiet. We are going to take an early lunch break at 11 a.m. So we'll see where we are in the hearing of that, and we will break for lunch from 11 to 12:15 and then resume the meeting. So if everybody helps me make sure that we get that timing right, Rick Gaffney would needs to leave the hearing at that point. I'd like to now announce the standard of appeal. With respect to the EMC's decision today, EMC Rule 7-13 applies, wherein a decision appealed from may be reversed or modified or remanded only if the commission finds that the director's decision is 1, in violation of the code or other applicable law, or 2, clearly erroneous in view of the reliable, probative, and substantial evidence on the whole record, or 3, arbitrary or capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion, unquote. Move now to announcements about the exhibits and prepared testimony. The commission is in receipt of appellants exhibits 1 through 19, with exhibit 9 being created in error. There's nothing there. And we are also in receipt of appellants exhibits A through N. I'd like to ask the DEM parties whether they have gotten their copies of those appellant exhibits. I see none.
I have received mine.
This is
Okay.
Ramsey Mansour. I did receive mine as well.
This is Robin Bauman. I have received mine as well.
Okay. So Robin Bauman, you're also a participant. And we missed you when we were recording who was here. So the commissioners, have you all received the full extent of the appellant's exhibits?
Rick Gaffney, yes, I have.
Okay, I don't know that we need a roll call, but
Yes.
just to make sure. Okay. In the interest of time and efficiency, I have authorized as chair that in lieu of taking direct testimony, the parties have submitted prepared testimony pursuant to EMC Rule 3-13E. The prepared testimony is subject to cross-examination of the witness on matters contained in the prepared testimony. So we'll start with the appellant. The appellant has prepared testimony that it submitted with its pre-hearing brief on December 17th, 2021. And here I need to ask if everybody got a copy of that. Since it's not labeled as an exhibit, we would like to designate it as appellant exhibit 20. Are there any objections to that? Okay.
So I'm sorry, Madam Chair, if I may interject, I think just for clarity, what the chair is saying that appellant submitted prepared testimony, it wasn't labeled as an exhibit, but we want it to become a part of the record. So we would like to label that exhibit 20 if the parties don't have an objection to that. Do you have an objection, Mr. Kai? Richie or Richard? Okay, thank you. I'll label it as exhibit 20. Thank you, Chair.
Thank you. Yeah, this is my first run through as a hearing officer, so Kira's keeping me straight. Regarding appellees, the DEM prepared testimony, appellee has submitted on December 20th and 21st, prepared testimony of Inspector Tony Nakatani, that's exhibit D, and prepared testimony of Director Mansour, exhibit G, and prepared testimony of Robin Bauman, exhibit L. Did everyone get copies of that? The Richards? Yes. Commissioners?
Yes, I did.
And I'll assume DEM has their copies. This one I may ask Kira to step in and explain if you don't follow it. Are the parties willing to stipulate to the submission of any exhibits or all exhibits, and which exhibits are stipulated to?
Director Mansour is fine with stipulating to all exhibits from both appellants and of course our own appellees.
We're in agreement with all of the exhibits.
Okay, great.
Thank you. For the record, I will, on behalf of the commission, receive all appellants exhibits 1 through 20 with the exception of 9 and appellees exhibits A through N. Thank you.
Thank you very much. Now we will start the contested case hearing with opening statements. If you would like to make them, please ask you to keep them to about 5 minutes. And appellant can go first. Who is going to be speaking on behalf of Kayala?
Chair Adams, I will be speaking on behalf of Kayala Partners. This is Richie Henderson.
Okay.
We in the same office as my father, Richard Henderson. And I would like to address the chair and members of the commission and say that we are here today to ask for your favorable consideration of Kayala Partners LLC's appeal from the decision in Director Ramsey Mansauer's letter dated June 10th, 2021, denying our request that the billing for the property at 755944 Ali'i Drive, Kailua Kona, be changed from 2 service charges for sewer service to a single sewer service charge, and that the amounts illegally overcharged by the sewers division since July of 1998 be refunded. In the course of our testimony further on in today, we'll go into the section 2131 that explains the code and the chargeability of the county's wastewater department and what can happen. Finally, the Environmental Management Department Sewer Division has for the past 23 years collected a double charge for sewer user fees from Kayala Partners and therefore has unjustly enriched itself. Supreme Court Justice Nakamura has described unjust enrichment as a claim for unjust enrichment requires only that the plaintiff prove that she or he conferred a benefit upon the opposing party and that the retention would be unjust. And that is Dewart versus Aloha Plastic Recycling, Inc., 105 Hawaii, 490-100, P.3D 60 74 2000. Thank you for your favorable consideration of our evidence and of our petition requests to change the sewer user fee to 1 charge, and that the amount of unjust enrichment of $7,888 be refunded to Kayala Partners. Thank you very much.
Thank you. Appellee, do you have opening statements and who will be making those?
Yes, thank you, Malia K. Kai for the director. Good morning, commissioners. I kind of want to keep this real simple. This is not about unjust enrichment. This is about a decision was made by a director back in 1998, and that decision was correct. And what's being appealed now today is the decision of this director, not the director back in 1998. So if you want to, the commission will be looking at is, did this director violate the law, abuse his discretion, or was his decision clearly erroneous? And I think the answer to that, and I think the facts show it clearly, is no, it wasn't. And so I don't think the commission has the evidence to overturn his decision at this point. As I laid out in my brief, the appellants had years and years of notice and knew that, that they were being billed for 2 units. Had they come forward earlier, back in 1998 or even in 2000 when the first change was made to their bill, then this would all have been avoided if the decision was incorrect. And that's what we're here. We're not here to decide whether the decision is correct or not. You're here to decide whether it was an abuse of the discretion, clearly erroneous, or a violation of the law. So thank you very much.
Thank you. Now it's time for the appellant to put on its case. The appellant has an opportunity to present its case on the appeal pursuant to HRS 91-10-5. Appellant has the burden of proof, including the burden of producing evidence, as well as the burden of persuasion. The degree or quantum of proof shall be the preponderance of evidence. To prove something by the preponderance of the evidence means to prove that something is more likely so than not so. It means to prove by evidence which, in your opinion, not in my opinion, convinces you that something is more probably true than not true. It does not mean that a greater number of witnesses or a greater number of exhibits must be produced. Appellants Exhibit 20 includes the written testimony of the managing partners and representatives of Appellant Kayala Partners, LLC. I will now swear in Richie Henderson. Do you, Richie Henderson, solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Since Richard Henderson is not intending to provide testimony, do I need to swear him in too, Kira?
I would, Chair, just in case commissioners or Ms. Kirkai have questions and Mr.
Yeah.
Richard Henderson wants to provide answers, I would ask that you swear him in. Thank you.
All right, then Mr. Richard Henderson, do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Is there anything else in addition to the Exhibit 20 that either Richie or Richard Henderson would like to add?
Chair, I think that we have presented our case pretty succinctly in what we've provided the commission already.
Okay,
I
thank
would
you.
like to reiterate the fact that a definition does not give you authority to make a charge. The authority is contained in the code under section 2131, which we provided you. And that stated sewer user charges for residential customers shall be billed as follows. And the sewer user charges for residential customers shall be assessed to all lots accessible to a public sewer or public gang cesspool, whether connected or not, under charges for sewer service to residential customers, which include service for single-family dwellings, duplexes, housing projects, condominiums, townhouses, apartments, and dormitories shall be according to the schedule shown under 2136.1. Unoccupied units will be assessed a monthly fee equal to the current monthly service fee. It is clearly stated that the unoccupied unit, as defined previously, is applying to those units listed above, namely single-family dwellings, duplexes, housing projects, condominiums, townhouses, apartments, and dormitories. It can't be any simpler than that. Again, you cannot use definitions to charge as authority. So I would say that in essence, our case rests on the proper interpretation of the code. And I would add, in light of council's opening statement and the 143 billings that have been provided to Kayala Partners over the past year, that we were not provided the sewer user card that is contained in their files, which states that we were being charged from the outset 2 sewer user fees. And clearly, as our evidence is presented, there is no difference in wastewater loading between a single-family residence that contains within it a laundry facility and a single-family residence that has an out structure that contains the laundry service there. Given the same amount of water consumption, there is no unproportionate wastewater loading. So we stand on the law that says that right now, the wastewater division is in violation of federal regulations in charging 2 sewer user fees to Kayala Partners. And if the sewer department is looking for their funding from the EPA and being in violation of their mandated change in how they apply sewer charges, that this commission should take a look at what's going on in this case and make the right decision. We'll have further evidence as we cross-examine the witnesses of the DEM. Thank you.
Thank you. Do any of the commissioners need more time to read the testimony? Seeing not, we'll move to cross-examination. Ms. Kakai, cross-examination of Richie Henderson, and I suppose also Richard Henderson, if you wish.
Thank you,
Proceed.
Chair, or Chair Adams. We have no questions at this time. We are confident in our case. Thank you.
Okay. Do any of the commissioners have a question of the Hendersons?
This is Commissioner McIntosh. I was a little confused that, I don't know if I asked the question now, but earlier they said that they didn't receive the billing printings we've gotten. So I was wondering what they did receive, or if that's pertinent or not, I don't know.
I think that's a question for either of the Hendersons.
Richie?
I'm sorry, but whoever was speaking, their volume was so low, we couldn't hear the question.
All right, what I was asking was that you stated that you did not receive these billings that are in the printouts that we've been given. So I was wondering what they actually sent you, if it was included in what we've been given or not.
In answer to your question, what we were not provided with was Exhibit C, which is their sewer wastewater card. That somewhere on there shows that there's going to be 12 hookups. I don't know. That's what we didn't receive. We received a bill from the beginning, but as any person that gets a bill from the county thinking that it's correct, just opens it up, writes out the amount, puts it in the mail and sends it in. And we've done that for 143 billings.
Did that answer your question, Commissioner McIntosh?
Yes.
No, I had a question. This is Georgine Adams. Is this outbuilding, laundry building, however you are characterizing it, is the wastewater from that shower, toilet, sink, and washing machine connected to the public sewer directly? Or does it go to the house and then the house's connection to the public sewer?
There is a Y connection that brings in that sewer to the house sewer, and then a single connection to the lateral to the sewer collector line in Ali'i Drive.
Thank you. Are there any other questions? Make sure I follow this right. Ms. Kakai, do you have any follow-up questions? Redirect?
No, Chair.
No. Okay. Next, we're on to redirect examination. Do either representative of the appellant have any additional testimony to give based on the questions that we have asked? If none, does the appellant have any additional witnesses today?
This is Richie Henderson. No, we don't.
Okay, thank you. So the parties did stipulate to the exhibits, so I don't need to do that piece. And so it sounds like we are now closing the appellant's case in chief. And we have received the exhibits into the record.
I'm sorry, Madam Chair, if I may interject briefly.
Please do.
This is kind of it's an odd setting, so sorry for interjecting, but I guess I would give the commissioners a last opportunity to ask any questions of the appellant, and this could be related to any of the exhibits, any of their testimony that they gave today, or any questions that you have of the appellant. This is the time for the appellant to prove its case. And so I want to make sure that the commissioners have the opportunity to ask any questions that they might have.
Okay, thank you for that clarification. So any questions you have of what has been said by the appellants or any of their exhibits from the commissioners?
This is Commissioner Gaffney. I have a couple questions. I'm curious, what other facilities in the main residence are connected to the sewer? In other words, is there a kitchen? Is there another bathroom? What else is connected to the sewer?
This is Richie Henderson. Commissioner Gaffney, in response to your question, there is a kitchen sink. There is an upstairs toilet, sink, and shower. And there is an outside shower, sink, and toilet right at the front door. The house was built on the original 1864 stone wall foundation, and Ossipoff, the architect that designed it, did not include within the structure any laundry facilities, and that was put on the outside where a 20,000 gallon catchment tank needed to be installed and enclosed because Kona did not have municipal water at the time. And in that outside catchment tank storage shed area, he housed the laundry area, bath, and toilet.
Thank you. And I have one other question. Obviously, before the sewer system was put in, there was a cesspool
That is correct.
on the property. And how much use does this house get?
In my lifetime, the house was finished, I guess, in 1953, the year I was born. Growing up here in Hawaii, we spent our summer vacations over there for 2-3 months a year. And then more recently, the house has maybe a weekend a month or 2 or 3 weeks a month, depending on family usage of it, vacations and stuff like that.
So all the use is by the family. It's not a rental unit.
The family and family friends, close friends.
Thank you.
Are there any other questions from the commissioners or Having heard that from Appellee,
No questions.
okay, seeing none. We'll move on to the Appellee's case. Ms. Kakai, which exhibits and witnesses are you calling first?
Thank you, Chair. First witness is Director Ramsey Mansour.
Okay, Ramsey Mansour, do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Is Exhibit G your written testimony?
That's correct.
Do the commissioners need any time to read through Exhibit G? All right, is everybody okay? Moving on then, do you have any thing to add, Mr. Mansour, Director Mansour, to your written direct testimony?
Just as I was listening to Mr. Henderson comments about the Y connection to the sewer, every Y can consider it as a separate connection. So you pretty much have two connections tied into the main sewer line. If you don't have that standalone building, you don't need the Y connection. And thus you only have one connection, which is one unit. In his own definition of describing the property, he's stating in page 2, main building and separate building. The definition for building within our chapter is very clear. Let's see what it is. It says building a house or sewer means that portion of the sewer lines extending from a building to the public sewer. And he just stated he had a Y connection to that sewer. So that by itself gives the impression it is two separate buildings, two separate connections. In addition to that, I just state it is, when I first took on that request, and it's not an easy decision that was made. I had to speak to my staff, I had to do research. And the code is very clear. When the code was written, it went through public hearing. Mr. Henderson could easily attend these public hearings, and he could have voiced his objection during the public hearing for the code establishment. That's all I have. Thanks.
Okay. Do the appellants have any cross-examination of Mr. Mansour?
Chair, this is Richie Henderson. Yes, we do.
Go ahead.
In your direct testimony, item number 10, you stated that the tank house building qualified as an unoccupied unit as currently defined. Director Mansour, do you know where the term unoccupied unit is used in Chapter 21?
Can't hear you,
You're
Ramsey.
on mute, Ramsey.
Yeah, I'm sorry, I have to mute myself. Yes, I did drive by the property, but I did, like I said, just to satisfy my own curiosity. It is from an engineering point of view, it is a structure, it's a building that stand detached. structure. So for me to imply that definition, it was clear to me that definition complied with that that building. It may have been back, I cannot speak what went on back in the old days. If it was water catchment, I'm sure it was modified. It has windows, it has doors, it has, as you have stated and testified, it has a toilet, it has a water heater. All that plumbing fixtures fit the definition of the code. And it is a building as you just defined it in your own testimony.
Director Mansauer, the term unoccupied unit is found in only 3 places in all of chapter 21. In the definition as section 21-2, in section 21-29, sewer user charges for non-residential customers, and section 21-31, sewer user charges for residential customers. Director Mansauer, are you familiar with section 2131 of the Hawaii County Code, which gives the department the authority to charge a sewer user fee for residential customers?
Yes,
That section is made up of 3 sentences. 1, sewer user charges for residential customers shall be assessed to all lots accessible to a public sewer or public gang cesspool, whether connected or not. 2, user charges for sewer service to residential customers, which include service for single-family dwellings, duplexes, housing projects, condominiums, townhouses, apartments, and dormitories, shall be assessed according to the schedule shown under section 21-36.1. 3, unoccupied units will be assessed a monthly maintenance fee equal to the current user fee. In your understanding of section 21-31, does the last sentence refer to types of residential units listed in the second sentence?
it's defining these units, and the building that you have defined under dwelling unit means any habitable room or group of rooms. So even if your building is outside the detached, it has the possibility of being, like I said, I cannot speak in the past, but it's definitely have the plumbing fixtures to qualify. Therefore, it falls under the same definition of unoccupied unit.
Director Mansauer, is there any language in section 21-31 that gives the director the authority to charge a sewer user fee for a storage room, utility room, and bath?
And it's not qualified as storage unit or utility unit. It's just in your own definition, you define it as a building. And our even own chapter defined the building. So it is a detached building. A storage room doesn't, most of the storage room doesn't have a toilet, doesn't have a water heater, it doesn't have all these plumbing fixtures. Storing room is for storage. And that's totally has different definition than a building or detached building. You have stated earlier to Commissioner Gaffney that the resident itself has the plumbing fixtures to qualify it as a building. So you have the same building mimicking the same plumbing fixture as the resident house. And thus, then you have 2 units. It's not attached, it's detached. It's about 40 feet away from, plus or minus, from your main residence. So it become a detached unit, detached structure, detached building, and it qualifies for a dwelling unit. And you have a wide connection to it.
So in the code, you're saying that the code allows you to charge for a storage building.
I think that's where the disagreement, you call it a storage building, I call it a building of detached accessory building.
Director Mansauer, Are you familiar with the Hoyt County Ordinance 9277, Bill 595, the purpose of which was to revise the sewer billing system to comply with the 1972 Federal Water Pollution Control Act, PL 92-500?
Not in detail as I was reading it, with what I was supplied.
This important ordinance was passed so that the county could receive grants through the Environmental Protection Agency. Are you familiar with the federal regulation that required that the system must collect sufficient revenue to ensure that the federal funded treatment works are properly maintained and operated, and that
Yes.
all users of the system pay their proportionate share based on the user's proportionate wastewater loading?
Yes,
Director Mansauer, does a residential dwelling that has a laundry and bath area located in an annex building create a larger wastewater loading than a dwelling that those facilities are located within the dwelling if both have the same water consumption?
no, it does not, because it has two separate wides. So now that additional building with the wide connection to it, it adds additional loading because it's a standalone detached structure. If you don't have that structure, you don't have the Y that connects to the sewer. You only have one Y to the main residence. Now your lot has two separate Ys connecting to that sewer.
The comparison, Mansauer, was to the laundry facility located within a single family residence and a laundry facility located outside of the single family residence. Does that have a disproportionate share of wastewater loading given the same water consumption?
If it's the same water consumption, it's the same loading, but you have two different laundries and potentially the probability you're going to have two different uses. So the water consumption, unless, like said, I think one of the commission asked if the water consumption has changed. So I don't have access to your water consumption, but this has been looked at as connection to the sewer. When you have two Ys, two connection, that's going to two possible loading to the sewer.
Well, as a correction, there's only one Y. There's not two Ys. Director Mansauer, in your testimony, you stated that you were familiar with the term unoccupied unit. Section 21.2, the definition of unoccupied unit, ends with the wording "and currently receives a water bill." Do you know if that unoccupied unit receives a water bill from the Department of Water Supply?
It receives a water bill through your property. I'm sure when you turn the faucet on, you have water, correct? So that water is being billed through the water department. So that unit receives water unless it receives a water bill. If it's combined water bill of the resident, still receives the water bill. Otherwise, you won't have water to the plumbing fixtures. So common sense, you turn the water on, you got water out. Somebody's going to pay for the water. I'd imagine you're getting a water bill.
If there was no water bill for the residents at 755944 Ali'i Drive, Kailua Kona, would you change your decision regarding the charging of the tank house a separate sewer user fee?
As I stated in my prior letter to you, Mr. Henderson, the code is very clear about having plumbing fixtures. We asked if you don't want to be billed or for us to change our mind. These fixture units and the detached structures need to be disconnected to qualify it, especially when you have a toilet. That's black water that's going to the sewer. It needs to be disconnected to qualify for us to change on at this point.
Director Mansauer, in your direct testimony, you said that the subject property receives a water bill as shown by the bills included. There was no water bill in the exhibits accompanying your testimony. only wastewater bills. Was this because there is no water bill for the property located at 755944 Ali'i Drive, Kailua Kona?
The water bills are issued by different department, not my department.
Your testimony stated that you included water bills in the exhibits and they were not there.
I refer that to our council. I think some of these exhibits were put together, or we could refer it to my agreements manager.
Director Mansauer, based on your testimony, item number 11, if there is no water bill, should the department should not have charged Kaiala Partners a sewer service fee for the unoccupied unit for the past 23 years.
Sorry, clarification needed. You're referencing number 11. Where in there does it say that Director Mansour said that a bill was included? I think that there needs to be a clarification. He means
Number 11 in his testimony
yeah.
states, as currently defined, unoccupied unit means a unit that is not occupied, but has accessibility to a sewer, plumbing fixtures located on it, and currently receives a water bill. The subject unit is accessible to sewer as shown by the sewer connection card, has plumbing fixtures connected to it as shown by the pictures of the laundry, sink, and water heater, and the subject property receives a water bill as shown by the bills included.
Okay, and then I'll clarify that his testimony was the bills included with your exhibits.
I need to step in. Ramsey, you're coming across a little garbled. I don't know if there's anything you can do to get closer, enunciate. I'm not sure where the problem's coming from.
I think I have construction. We just moved to the new building and I have construction across the street. So I cannot go out and tell them to stop construction like you have mentioned. You could tell the gardener to stop, but I do apologize for that. So I'm trying to control the mic so you guys don't hear the drilling and the sound.
Thank you. Excuse me, do you have any more questions? Mr.
Yes, I can continue. Director Mansauer, if the inspector who authorized the charging of 2 sewer user fees for the residents and tank house at 755944 Ali'i Drive made an determination, partners has paid a total of over $788 in charges to the department, would this constitute a situation where the department was unjustly enriched?
In my opinion, it does not. If the inspector made a mistake and you were aware of it early on, it could be resolved as was mentioned earlier. I cannot, if it challenged earlier, maybe it could be looked at and looked at again, but I don't believe so.
Under Hawaii law, the term unjust enrichment has been described by Justice Nakamura of the Hawaii Supreme Court as, quote, claim for unjust enrichment requires only that the plaintiff prove that he or she conferred a benefit upon the opposing party and that the retention of the benefit would be unjust. Cited from DeWard versus Aloha Plastic Recycling, Inc., 105 Hawaii, 490, 504, 100, P.3D 6074, 2004. Do you agree with Justice Nakamura's description of unjust enrichment?
If an inspector made a mistake, the intention, it's a mistake. It's not for the purpose of purposely enrich the department. That I'm not familiar with the cited case that you have been citing in this conversation, but if intentionally it was shown with disregard to the code, that's different. But if an inspector, I'm saying hypothetical, as if a mistake was made, it was not intentional. But in this situation, the inspector did the right thing based on the codes and the definition of the code.
In the case of Kyle Partners LLC, since 1998, it has conferred a benefit to the county's Environmental Management Department in the sum of $7,888 in erroneous sewer charge fees, that the county's retention of these fees and that the county's retention of these fees is unjust. The remedy for unjust enrichment is restitution, the return of $7,888 to Kyle Partners. Based on the above and what we've reviewed, do you agree that these funds should be returned to Kyle Partners by the Environmental Management Department Sewer Division?
I don't think so. I still believe that the inspector did the right thing based on what was given in the code. It's a county code. He was doing his job or her job. And as far as the interpretation of the code and doing their job, I think they did it right.
No further questions, Chair,
Thank
of
you.
this witness.
Okay, understand. Ms. Kakai, do you have redirect examination of this witness?
Not at this time, Chair. I'll allow the commissioners to ask their questions.
Okay, do commissioners have question of Director Mansour?
This is Commissioner McIntosh. This is Commissioner McIntosh. I had a question regarding the Y connection for the director. So if the building didn't have a Y connection, it went to the main building or the house, would it still be considered an unoccupied unit? I was just trying to figure out when buildings are charged twice, or how that works.
If it doesn't have a Y connection, then it won't be serving, it won't be distributing to add wastewater into the sewer system. So it won't be considered as unoccupied because it's not connected to the sewer. So I would imagine the fixture units within that building won't be contributing to the sewer system that we have, the public sewer system.
Are there any other questions from commissioners? D. Fulton, what are your questions?
I'm almost embarrassed to have to ask this question or to phrase it this way, but I'm looking at the code that has been quoted here many times. And it starts out, sewer user charges for residential customers shall be assessed. And then it goes on to say unoccupied units. So I guess my rather silly question, but needs to be asked is, has this unit ever been used as a residence? Was it ever intended as a residence?
I don't know that that's a question.
No, the answer to your question, this is Richie Henderson. It housed a 20,000 gallon storage, water storage catchment tank. And when that was removed, it was turned into storage. So it was either storing water or it was storing items, as the pictures that were provided show.
So just to recap, that unit, which does not have its own connection to the lateral, does not have an independent connection to the sewer system. It is not a residential customer, because nobody has ever resided in it. Okay, and it has never received an independent water bill. I just want to make sure all those points are straight with me. Has it ever received an independent water bill?
That unit that we're talking about, that detached building, does not have an individual address. it is included in the address at 755944. That unit does not have a cooking kitchen facility in it. It does not have a dining area. It is
Sorry,
strictly
Chair,
a laundry room.
the appellant has had their chance to present their case, and we're supposed to be questioning Director Mansour.
Thank you. I think we're looking for questions that Ramsey Mansour can answer. And if we go back and reopen appellants part of the case, then you could ask all those
I
questions.
apologize. I thought she was asking me for clarification.
I think we can get there, and it's fine that you've given the information, but I think just to follow the order, now it's not the time. The time now, if other commissioners have have no more questions for Director Mansour, we move to your second witness, if you have one.
I have an additional question, please.
Oh, you disappeared. There you are. Okay.
Yeah. Sorry. Can Director Mansour, can you describe the decision that was made in 1998 by your predecessor, please?
I cannot. I don't know. I would imagine they utilize the same code I'm using today. But I don't know what went through their mind.
Yeah,
The only common thing between us and them is the code.
So Corporation Counsel Kekai asked or mentioned this 1998 decision. Can you describe it for us, or should we do that at another time?
That's one of the exhibits.
Sorry, if you have questions about 1998, I think they would be better for Inspector Nakatani. She would have be able to answer questions about the process that was followed back then, if that's what you would like.
Okay, I'll hold that question.
Okay. Thank you. Any other questions from the commissioners for the director?
This Commissioner McIntosh, I have one more question. Is there a
Okay.
statute? Is there a statute of limitations for the that they can request remuneration? I kind of thought, the government has set in the law how far back they could ask to be reimbursed for if a mistake was made for this.
Yeah, good question.
I think Malia, our corporation counsel, had shown the statute. It's 2 years to 6 years, I believe. It's stated in the document before you.
Do you remember which exhibit, Malia, you had that information in?
That was provided in my brief on page. The basic law is that if this were deemed a claim, you have 2 years. If it was deemed a contract, you have 6 years. So it is on page 9 of my brief, last paragraph.
Yeah, page 9, the last paragraph.
Oh, I see.
Did that answer your question, Lee?
Yes, it did.
Okay. Anybody else?
I have a follow-up question.
Rick? Yeah.
As I read the brief, it was my understanding that was state law. Is there anything in the ordinances relevant to the sewer charges or in county law that specifies the statute of limitations?
I refer that question to our counsel.
There's nothing in the sewer chapter that addresses residential, only non-residential. Non-residential customers have 1 year to bring claims.
Does county law have specific statutes of limitations, or do they defer to state law?
Usually when we go to court, we're using state statutes.
Thank you.
Anything else from the commissioners? Seeing none, I ask Malia Kakai whether you have other witnesses.
Yes, thank you. We would now like to call Inspector Antoinette Nakatani.
Okay,
Aloha, everyone.
I need to swear you in. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
And is Exhibit D, as in dog, your written testimony?
Yes.
Okay,
Sorry, Chair, just one clarification for the record. I realized that a second half of her answer for number 11, the written testimony was cut off. So I just would like to add it here. Wait, let me just double check that it's number 11 and not number 10. Oh yeah, so it should actually state, yes, looking at the connection card on file at DEM Wastewater Division, the determination of 2 units is correct, but that got cut out. So I just wanted to add that for the record. Again, it should read yes, comma, looking at the connection card on file at DEM Wastewater Division, the determination of 2 units is correct.
Okay, can you email myself and the parties and Peter a copy of that to complete the record to properly show Exhibit D? And then you can have Ms. Nakatani testify further to what you stated.
Okay.
okay. Go ahead with it. Your
Let's go. Delicious. Mm-hmm.
so do appellants have any cross-examination of this witness?
Oh, I'm sorry, Chair. Did
go ahead.
we swear in Ms. Nakatani?
Yes, I did.
Okay. And does Ms. Nakatani have anything in addition to her written testimony to offer?
Well, maybe that's the way to read in what you should have had written in answer to number 11 in your testimony.
Are you asking me a question?
Yeah, I think, why don't you just read the full answer to number 11 in your written testimony? That way it'll be on the record.
Malia, you have that paper, yeah? I only have the older one. Hang on, sorry about that, guys.
Or perhaps we could just answer the question now. Was that a correct determination?
I would say that looking at the connection card that was at our office on Railroad Avenue, that 2 units were there at that time in 1998 and billed accordingly.
Okay, I'm sorry. So it's for you, Ms. Kakai, if you have any more questions for your witness?
Nope.
No. Okay, then
Go.
Mr. Henderson, do you have cross-examination of Ms. Nakatani.
Yes, Chair, I do have questions for Ms. Nakatani.
Go ahead.
Good morning, Ms. Nakatani. When did you leave your position at the Department of Environmental Management?
December 1st, 2021.
Thank you. Ms. Nakatani, during your 28 years with the Department of Environmental Management, were you familiar with Ordinance 92-77 that changed the county's user charge system to comply with federal guidelines?
I am aware of it, yes.
You are familiar with the ordinance?
I am somewhat familiar, I knew it happened, but yeah.
Ms. Nakatani, is it true that those guidelines require that the system must collect sufficient revenue to ensure the federally funded treatment works are properly maintained and operated, and that all users of the system shall pay their proportionate share based on the user's proportionate wastewater loading?
I've heard of those statements before, yes, sir.
So you say in the affirmative, it is true. Ms. Nakatani, in your inspection of properties, if laundry facilities are located outside of the main residence compared to residences with laundry facilities within the residence, is there a difference in wastewater loading between the two residences given they had similar water bills from the Department of Water Supply?
That I wouldn't be able to answer.
Do you need me to repeat the question?
No, I'm sorry, sir. I don't have knowledge of what the loading would be coming out of that separate building. So I wouldn't have knowledge of the additional loading added, sorry.
Well, the question stated that they both received the same water bill.
Correct.
Would there be a difference if the laundry was located outside of the main residence rather than within the residence?
I'm not sure, sir.
In 2021, when you inspected the property at 755944 Lee Drive, did you have access to the residence and the storage/accessory building? And did you observe laundry facilities located in that structure?
In the separate unit, yes. In the smaller unit, yes.
And so you did not see any laundry facilities in the main residence?
No, I did not, sir.
In your testimony, you stated that in 1998, when an inspector inspected a property, they considered that if it was habitable and had plumbing fixtures, then it was considered a unit, and you agreed with that determination.
Yes, sir.
Are you familiar with section 21-2 that contains the definitions?
Yes, sir.
Are you familiar with section 2131 of the Hawaii County Code?
Yes, sir.
Is the term habitable unit used anywhere in section 2131?
No, sir.
Isn't it true that it is only in section 2131 where the department is given the authority to charge single-family residences a sewer user fee?
Can you repeat that question?
Isn't it true that it is only in section 2131 where the department is given the authority to charge single-family residences a sewer user fee?
I'm not sure if it's the only part of the Hawaii County Code that states that.
That the county can charge a sewer user fee? You
Yeah, I'm
think
not
that
sure
might
if
be in
that's
the
the
building
only
code?
where, the only location.
Okay. Isn't it true that in section 2131, the term unoccupied unit is referring to various structures listed earlier in that section?
That's what that would be my interpretation, yes.
Ms. Nakatani, isn't it true that in section 2131, there was no mention of a detached storage / accessory room, laundry area, or bath as one of the structures?
You're correct. It doesn't state that.
Ms. Nakatani, based on the language of section 2131 and your inspection of the property, do you agree that the inspector was in error when charging 2 sewer user fees to the single-family residents at 755944 Ali'i Drive as set in 1998?
I'm sorry, I can't agree with your statement. I would have to say at that time, there were 2 units. This is what, reading this document and my experience in the wastewater division, I would say there were 2 units at that time.
You were saying that there were 2 single-family residences located on the property.
There were 2, yes, 2 units.
2 single-family residences.
Yes, sir.
Complete with kitchen, cooking facilities, dining area, etc. Okay. Ms. Nakatani, do you agree that the sewer division, by charging the property at 755944 Lee Drive for 2 sewer user fees, is a violation of the federal regulations about proportionate wastewater loading share?
I'm not sure about that, sir.
Do you agree that based on your current understanding of section 2131 and the federal regulations, if you were asked today to set the sewer user fee for the property at 755944 Lee Drive, you would recommend a single sewer user charge for the property?
Today,
Yes.
sir. When I went out, I would say that it is a storage building at this time, yes. Because there's no, there's a lot of, that's what it's being used as now.
So
But
your
that doesn't
answer
mean that
is
it could
yes.
turn to, but that doesn't mean that it could be cleaned out and returned to another habitable space.
I think we already went over the definition of habitable not being in the code, Ms. Nakatani. So your answer is today, you would recommend a single user fee for that property.
Because, yes.
Thank you. That's all the questions I have, Chair.
Thank you. Any redirect examination, Ms. Kakai?
Ma'am.
I'd like to just make one more clarification if I could.
Go ahead.
That unit also has plumbing fixtures, which under the county code would qualify it to be billed as a unit, separate unit.
So are you changing the answer that you gave previously?
I'm just making a clarification that it does have plumbing fixtures on it, and that's part of the code, right?
So you had been asked whether you would bill for 2 units for that location. And I believe you said, no, you would bill for 1, but are you?
Not at this point, but it could be billed for 2. Because of the plumbing fixtures, right?
Okay.
Am I confusing everyone?
I think so. I mean, the issue is, I'll use this as the commissioners asking questions. So I'm asking questions as Georgine Adams. The building has a toilet. and other things. So it is discharging or has the capability of discharging to the sewer. It's connected up through a Y connection, but it can contribute sewage from that unit. And therefore, it gets a charge as for a sewer fee, as does the house, which also has plumbing, a toilet or two. And so that there are two charges going for that wider double property. Is that appropriate or not?
I would say, try that again. I'm sorry, Miss Adams.
That's okay. It is confusing. I'm trying to figure out how to answer the question simply. There are two units that have the capability of sending sewage to the sewer, public sewer. Yes or no?
Yes,
And therefore, there would be two sewer usage bills.
we
Yes.
would, yes, we would, in the field, we would consider it 2 units.
Whether or not anybody ever flushes the toilet.
Whether or not anybody flushes the toilet, because there are plumbing fixtures and there's water.
Thank you. That's my question. Any other commissioners have a question for Ms. Nakatani? No, seeing none. Ms. Kakai, any follow-up?
Sure, just one quick one. Inspector Nakatani, or I think you have a new title now, so I'll just say Miss Nakatani. When you spoke about habitable, you used the term habitable because the definition of unoccupied unit I guess, tell me why you use the term habitable.
Habitable for inspection, sewer inspections would mean an area where you could potentially lay your head and would have the basic roof, roof, walls, things like that. That's what I would consider habitable.
So this unit that you inspected could possibly use as a studio.
That's what I would, yes, it could, yes.
Thank you. No further questions.
Okay, are we ready to move to your next witness, Ms. Kakai?
Yes.
I see a hand waving from Richie Henderson.
Yes, Chair. I would like to further address Ms. Nakatani's testimony that she recently provided.
Do you have a question for Ms. Nakatani, Mr. Henderson? A
Yes,
follow-up
I
question?
do. I
Okay,
do.
go ahead.
Yeah, Ms. Nakatani, if a property had a detached carport / garage that had laundry facilities located in it and a half bath, and you could actually lay your head down in the garage, are you charging 2 sewer user connections for that property?
I don't think we would charge for a garage.
But yet I could sleep in the garage. Is that not so?
Correct, but yeah, it's a little bit more than just laying your head. I mean, in
Oh,
this
that's what you were
situation, a
alluding to. If
garage,
you could just lay your head down, that would be good. Just have a roof and some walls.
correct. That's part of it, yes. But also a garage would be designated, right? I mean, you
No
would,
further questions, Mr. Chair,
Okay.
Mrs. Chair.
sorry.
Okay, anything again from Ms. Kakai?
I think Commissioner Gaffney has a question.
Oh, I see your hand. Rick Gaffney has a question.
Yes, I'd like to ask Ms. Nakatani, in your experience working for the department, how common was it for a single family residence to be charged more than one sewer fee?
You know, further back when they permitted Ohana housing, it was pretty common. Where you would have two separate units or dwellings charged sewer fees. So I'm not sure what it is now, but it is common.
Thank you.
Any other questions from the commissioners? Are we ready to move to your next witness, Ms. Kakai?
Yes, thank you, Ms. Nakatani. The director would now like to call Business Manager Bauman.
Good morning.
And you're Robin's phone on our screen?
Oh, actually, I'm calling in and watching you on my small iPhone.
Okay, that's just fine. I need to swear you in. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Is your exhibit, your written testimony exhibit L?
Yes, it is.
Everybody's got L and has had a chance to look at it? Okay. Move on to your, oh, wait a minute, I gotta do this right. Do the appellants have any cross-examination of this witness?
Sorry, Madam Chair.
Yeah, correct me, I know I'm messing it up.
Ms. Bauman, in addition to your written testimony in Exhibit L, do you have any additional direct testimony to offer?
No, not at this time.
And Ms. Kakai, do you have additional questions of Ms. Bauman?
I do not, thank you.
Okay. Thank you, Chair. Cross-examination, Mr. Henderson.
Okay,
Thank you. I understand that she was sworn in.
yes,
Thank you. Good morning, Ms. Bauman. Are you familiar with the property located at 7590-5944 Ali'i Drive, Kailua Kona? That has the residence and a separate building containing a storage, laundry area, and bath.
I am familiar with the sewer account.
Is this the address that is on the wastewater bill? Namely
I believe-
75-5944 Ali'i Drive.
Could you repeat that address again?
75-5944 Ali'i Drive, Kailua
Yes,
Kona,
that is.
Hawaii.
sewer.
I'll assume you said yes, that is the address on the
Oh, yes,
wastewater
yes,
bill.
it is.
Ms. Bauman, in your direct testimony, you stated that approximately 143 bills for sewer service fees had been sent to Kayala Partners since 1998. When a person looks at the bill, how do they learn if it is for more than a single user fee?
They would look at the number of units.
Ms. Baumann, the sewer bill has language that states wastewater residential and then has just one amount for the two sewer user fee charges. Is this making full disclosure and clearly showing the charging for two fees for a single family residence?
Prior to that total dollar amount, there is the number of units listed as 2.
Clearly identified.
Yes.
Ms. Baumann, if you were the owner of a single family residence and you got a sewer bill with just one amount on it for sewer services, would you not conclude that that was the charge for a single service?
Looking at the wastewater bill, I would conclude that I was being billed for 2 units. Based on
Yes,
the
that's
number of
because you're
units.
familiar with the design of the wastewater bill. But if you're just an average consumer looking at it with only one charge and not clearly defining that this was 2 units on that line, would you assume that it was for just one charge?
Sorry, witness can't answer an average person as she's a business manager for DEM.
Ms. Baumann, are you familiar with Hawaii Ordinance 9277, Bill number 595, the purpose of which was to revise the sewer billing system to comply with the 1972 Federal Water Pollution Control Act, PL 92-500?
I am aware of the ordinance, yes.
Is it true this ordinance was passed so the county could receive grants through the Environmental Protection Agency?
That would be my understanding based on how the ordinance was written.
Are you familiar with the federal regulations that require that the system must collect sufficient revenue to ensure that the federally funded treatment works are properly maintained and operated, and that all users of the system pay their proportionate share based on the user's proportionate wastewater loading?
Yes, somewhat.
Ms. Baumann, does a residential dwelling that has a laundry and bath area located in an annex building create a larger wastewater loading than a dwelling that has those facilities located within the dwelling, given the same water consumption?
I can't answer that. That's not in my area of expertise.
Ms. Baumann, do you agree that the inspector's assessing and the sewer division's billing for 2 sewer user fees for a single family residence says single wastewater loading is a violation of the federal regulations about proportionate share?
Sorry, could you repeat that?
Do you agree that the inspector's assessing and the sewer division's billing for 2 sewer user fees for a single family residence's single wastewater loading is a violation of the federal regulations about proportionate share?
No, I can't say that. I agree.
You do not agree with that? Yeah, that's right. Ms. Baumann, in your testimony, item number 11, you stated that you were familiar with the term unoccupied unit. The section 21-2 definition of unoccupied unit ends with the wording "and currently receives a water bill." Do you know if that unoccupied unit receives a water bill from the Department of Water Supply?
That unoccupied unit is, my understanding is receiving water. The water turns on and the property does receive a water bill. So I would say yes, it does receive a
Ms.
water
Baumann,
bill.
have you inspected the water bill that was submitted as Exhibit 18 in our opening brief?
Not in detail.
Ms. Baumann, is the address on the bill from the Department of Water Supply 75-5946 Ali'i Drive, Kailua Kona, Hawaii?
I do not have a copy of that in front of me.
That is the address for the vacant lot that is associated with the property. Ms. Baumann, is it true that there is no water bill from the Department of Water Supply for the property at 75-5944 Ali'i Drive, Kailua Kona, Hawaii?
If the property is receiving water, then there would be a water bill regardless of which address the water meter is on.
Ms. Baumann, in my previous question, section 21.2 definition of unoccupied unit ends with the wording and currently receives a water bill. It does not say whether or not it receives water or whether or not there is a meter there. It says and currently receives a water bill. Do you know if the unoccupied unit receives a water bill from the Department of Water Supply?
I would have to say if it's receiving water, it does.
Ms. Baumann, are you familiar with section 21-31 of the Hawaii County Code?
Yes.
That section is made up of 3 sentences. 1, sewer user charges for residential customers shall be assessed to all lots accessible to a public sewer or gang cesspool, whether connected or not. 2, user charges for sewer services to residential customers, which include service for single-family dwellings, duplexes, housing projects, condominiums, townhouses, apartments, and dormitories, shall be assessed according to the schedule shown under section 2136(1). 3, unoccupied units will be assessed a monthly maintenance fee equal to the current user fee. Is it true that in the reading of section 2131, the last sentence refers to the types of residential units listed in the second sentence?
Yes.
Ms. Baumann, isn't it true that there is no language in section 21-31 that gives the director the authority to charge a sewer user fee for a storage room, utility room, and bath?
Not described as such.
So I take your answer is yes, there is no language in section 2131 to charge for the description of a storage room, utility room, and bath. That's all the questions I have for this witness.
Okay. Getting lost here. Does Ms. Kakai have any questions for her testifier?
Not at this time, Chair.
Okay. Do the commissioners have a question for her? Rick Gaffney?
Yes, I have a question about the relationship between the DEM business office and the water department business office. How closely do you work together? What are the responsibilities for DEM's billings in relationship to the billings by the water department?
So we do work closely with the Department of Water Supply. For our commercial customers, those accounts are billed based on consumption. So we do get water supply meter readings from them. We are notified when a customer opens a water account in a sewered area, so that we know to begin billing. So we do work closely with the Department of Water Supply.
You're muted, Rick.
Sorry. When the Department of Water Supply informs you that there is a new account, how do they describe that account? Do they tell you something like single family residence, apartment building? What kind of detail do they give you that you use to make your decision with regard to billing of sewer fees?
You know, I apologize. I don't have a copy of the water application right now in front of me. We do get a copy of the water application, and if it's not stated directly, you know, on the water application, we would look at real property tax, what type of property that is.
Okay, thank you.
Are there questions from any other commissioners? Lee McIntosh?
Commissioner McIntosh, I had a question, but I'm not sure when I should bring it up. It was brought up that the water bill is for a different property than what the house is sitting on. That the sewer bill is referring to. They're two different. So are they running water across the TMK to the other lot? Is that what they're doing? I was confused when that was brought up.
That's what it sounds like to me. That it's possible that the meter is on the other TMK and serving, you know, both properties. I don't have that information in front of
Georgine Adams asked a question. I understand that the DEM is taking the position that because call that building, whatever you want to call it, does receive water, that water is metered and charged for to Alakai partners. Is that your understanding?
Yes, the water account could be charged to, you know, another person or another entity. For sewer, we bill the property owner, but yes, if it's receiving water, the property is being billed. Someone is being billed for that water.
I don't think you're the right person to ask this, but I want to figure out how to get it on the record anyway. There have been repeated citations of section 21-31, the definition of residential customers, which include, and then there's a list. It doesn't say only includes. It doesn't say also, for example, including. It's somewhat ambiguous. The way I read the sentence, it would say, here's an example, a list of things that would be included in service to residential customers. Would you interpret that language the same way?
Yes, I would.
Thank you. Any other questions? Okay.
Sorry, Chair, if I may just ask one more question of Ms.
Sure.
Baumann. Ms. Baumann, our sewer fees to pay for our wastewater system comes from two different things, correct? Two different pots, I mean, of money, basically.
I'm sorry, could you repeat that question?
The money that we use at the Department of Environmental Management for wastewater division, it comes from two different accounts, correct?
What do you mean by two different accounts?
Okay, so we have the general fund, right, which receives property taxes, and then the fees that we collect through user fee charges.
Correct.
Okay. So basically, every homeowner not only pays for, you know, the ones that are connected pay through fees. But it also is property taxes covers a portion of what pays for the wastewater division to pay for the cost.
Yes, the wastewater currently receives some general fund subsidy.
Okay, thank you. So it's not totally, everything is not based on fees, and therefore, if this property is only paying $200 worth of property taxes, then technically it's not paying its fair share of wastewater operation and maintenance costs.
Yeah, I mean, we're trying to get the fund to be, you know, self-sufficient.
Okay, thank you
But we're
for the
looking at
question.
it,
Oh,
Okay, that funny alarm I made on my phone was warning that in 10 minutes, now 9 minutes, we will be taking a recess. I'm trying to figure out if we're at a point of a natural break coming up, or if we can proceed to additional things.
Chair Adams, if I may.
Please do.
I think Richie had sounded like a follow-up question based on Ms. Bauman's answer. So I think if we can get that in so that it's still fresh, and then we can take a recess, because I don't think we're going to be closing the evidentiary portion before 11.
Okay. So Mr. Henderson, you had a question for Ms. Baumann?
Yeah, I had 2 points of clarification. And the first one was, Ms. Baumann, isn't it the inspector's job to locate where the water meter is and to make sure that it is on the property TMK that it is servicing?
No, I don't believe there's any requirement for the water meter to be located on the same PMK as the property that is being serviced.
And Chair Adams, in your description of section 2131 and the listing of the units that sewer charges apply to, I believe the law is inclusive, meaning that it contains what it is addressing. It is not, for example, we can charge the doghouse over here a fee. It's specific. That's what it's referring to.
We all have our opinions. I asked Ms. Baumann what she thought, and she answered me. And we can address those issues later in the hearing. I think we're okay in terms of, or did you have additional questions of this witness?
No, not at this time.
Okay. Where we do not have any additional exhibits except for a corrected version of Ms. Nakatani's testimony, written testimony, I believe. And anything else that would be added to the exhibits? Is that the way I'm supposed to put it, Kira?
Chair, I would say that we will withdraw the request to amend the exhibit and just go with her testimony that she
Oral
gave.
testimony.
Yeah,
Okay,
We will agree to that, and we have no further exhibits.
okay, thank you. The next,
So I think if, or I guess, do the commissioners have any other questions of Ms. Baumann at this time? Okay, and Ms. Kikai, you don't have any other witnesses? So are you resting, you're resting your case?
yes.
Okay, then, Chair, what I would suggest is we take a recess right now. And when we come back, appellant has the opportunity to present its rebuttal case. And so I think you stated earlier to come back at 12:15, come back on the same Zoom call, use the same information. And then just for purposes of the commissioners, I just do want to make one announcement that since we're still in the contested case hearing portion, the evidentiary portion has not closed. I just want to make sure that the commissioners understand that they're not allowed to go and do their independent digging of information. They're not allowed to talk to each other. Everything has to be in the open meeting. So, and that's for the purposes of sunshine law. So I just want to put that reminder out there. Thank you.
good. Therefore, we will recess now at 10:55 and resume at 12:15. See you then. Thank you. All the commissioners are back on the line, and I believe we can resume the hearing. Do I need to do a roll call or anything?
I think if you just announce everyone who's present. I know that Commissioner Burns is having issues with his camera. And I think he was going to turn his camera on once his connection was a little bit more stable. So I just want to keep that in mind with respect to the new sunshine law that commissioners need to be visual.
Well, fortunately or unfortunately, the governor has suspended that rule, but we will definitely try and get John back online visually. We have Commissioners Lee McIntosh, Georgine Adams, Dee Fulton, Rick Gaffney, and John Burns. And those are the commissioners. And I saw him, but I don't see him now. The Rich Henderson for the appellant. We'll wait till he shows up because he's on deck next. We have both attorneys, Kara Wong and Malia Kikai. There you are, Rich Henderson. So the next part of the hearing is the appellant's rebuttal case. And this is where I asked the appellant if they would like to provide additional testimony in response to the appellee's case.
Yes, I would, but I'm just waiting for my father to get on. He signed off, and so hold on one second. I think I sent him the email link for this to get on.
Okay.
Hold on one second. Hold on one second. We do have some. So yes, Chair Adams, we would like to put on our closing argument, if that's okay with you.
I'm sorry, this is Kira Wong, Deputy Corporation Counsel. Mr. Henderson, we are going to go to closing arguments, but right now, if you have additional testimony or witnesses that you would like to put on to rebut the DEM's case, you can do that right now. If you're just going to do closing arguments, then I'd ask that first the chair has to close the evidentiary portion of the hearing.
Okay, we have no witnesses that we're going to put on, and we've already cross-examined the witnesses from the DEM. So I think at that point, we're done with putting in any further evidence.
Okay, then I formally close the evidentiary
Sorry,
portion.
Chair, one second. Do I have an opportunity now to ask questions of Mr. Henderson, or has that opportunity passed?
Kara?
I would say, Chair, I would allow for leeway. We can allow Ms. Kekai to ask questions of Mr. Henderson, either Mr. Henderson, and then the commissioners will have an opportunity to ask further questions based on the answers that Mr. Henderson provides if they have additional questions. And then we can do one overall last time. If the commissioners have any other questions, then they can do that before we close the evidentiary portion.
Okay, I withdraw my formal closure. We're back to allowing some questions. So Malia Kekai, can you ask your questions of the Hendersons?
Yes, thank you, Chair, for the latitude. It's just a couple clarifying questions. Mr. Henderson, so the water bill that you guys provided as Exhibit 18, is there any structure on that address that is receiving water?
There is none.
Okay, so basically the water that is being billed does go to the residential property. Okay, thank you.
Yeah, so the meter is in front of the residential TMK address,
Okay,
and that's the property that has water on it.
okay, perfect, thank you. And also, Mr. Henderson, what do you do as, what is your occupation?
I am a broker in real estate at RSM Inc. And my license is RB 17688, which is displayed in my name on the Zoom meeting there.
Okay, and how long have you been a broker?
For over 35 years, practicing real estate.
Does your occupation also include property management?
Yes, it does.
Do the properties that you manage have wastewater bills or sewer fee charges charged to those properties?
Yes, we receive wastewater bills from the department.
And you guys review and pay those bills for customers?
Yeah, if the owner has asked us to do that. Sometimes owners maintain the water bill in their own name and don't turn it over to us to pay. But if they do, we do.
Okay, and so they are these all multi-units, or do they have just one residence on them?
Most are single family units. We do have one apartment building that my property manager manages
Okay,
in the lodge.
thank you. No further questions, Chair.
Do the commissioners have any additional questions for the Hendersons? Hearing and seeing none. Now, I will close the evidentiary portion of the hearing, and we will move to closing arguments. Is that right, Kira? Okay, Appellant gets to go first in making your closing argument. Mr. Henderson.
Okay. Thank you, Chair, for the opportunity to present our findings of fact and be able to address this problem that we've discovered.
Someone needs to mute their rustling paper. Okay, good. Sorry.
I think it's Robin's iPhone. Robin, can you mute your iPhone, please? Or if Peter, if you have the authority to, as the host, to mute it, are you able to do that?
The only people who have microphone access are chair.
Okay, well, in the spirit of time, proceed, Mr. Henderson.
Okay, thank you very much, Chair. Our case before the commission today is a case that is based on the sewer code as provided in 2131. Also based on the federal regulation, and that was found in Ordinance 9277. And our case rests on the code contained in the sewer billing and not in the building department code or any other code. It rests solely in the sewer department's chapter for residential customers, non-commercial. So having said that, I want to reiterate that federal funding is based on the users of the system paying their proportionate share based on the user's proportionate wastewater loading. And I believe we have shown that there is no difference between a single-family residence with a laundry inside of it compared to a laundry, be it in a detached garage or a detached storage shed, given the same amount of water consumption. It is based on the proportionate wastewater loading. And what that means is the amount of loading or the amount of water put into the sewer system. I also want to iterate that the code in 2131 provides specific charging authority there. It does not provide charging authority in the definition. It does not provide charging authority anywhere else but there in 2131 for single family residential units is what we're dealing with. And I think we really have to understand the definition of an unoccupied unit as it is used in the sewer code. And an unoccupied unit is specifically relating to those units enumerated above. And it makes sense that if a single family resident was connected to the water, was nobody living in it, unoccupied, it would be an unoccupied unit. And I think we have to understand that Black's Legal Dictionary defines dwelling, a house, in two, real estate, the house and all buildings attached to or connected with the house. And really clearly, the property at 755944 Lee Drive consists of a main residential building and an outbuilding that originally housed the freshwater catchment tank, later converted to a storage room. And that's where the architect put the hot water heater for the house from its inception, the laundry facility and bathroom. And it should be considered as one dwelling in accordance with the legal definition of a dwelling. Finally, I would say that this is a case that deals with fees charged from the get-go. And when you look at Wastewater's sewer card, I really don't understand, and it's not provided to the owner. It's an internal document of who the inspector was, what their qualifications were for determining, and whether or not they understood what the code is. And it's apparent from my questioning that the inspectors, the business manager, and the director are not totally familiar with the code. And as a consequence, Kiowa Partners has suffered an injury of $7,888 in being overcharged for 2 single-family residential units on one lot for 23 years. Now, there are 2 TMKs there that make up that property. But the laundry and the tank house and the main residential building are on 1 TMK parcel ending in 18. And it's been that way from the beginning. And even when there was a cesspool there, the laundry facility and the house tied into the cesspool. And it was only a matter of filling in the cesspool and extending that to the county's lateral and 1 connection. It was a single family residence, and it even states that in the card there. So I would say that this really is a case of unjust enrichment, and that the commission needs to really address the interpretation of the code found in 2131 and understanding the circumstances of not following the federal guidelines in looking for federal funding and not providing a proportionate wastewater loading to our property at 75/59/44. And we've already explained that there is no water bill designated for that property. The water bill goes to the adjoining property. Why that is, I don't know. Maybe it was a mistake, an error, just like the original error, and the county not really understanding what they're doing. And using a definition as the means of justifying a billing. Oh, it's unoccupied. Well, the doghouse is unoccupied. And I have a water tap to the doghouse. Does that mean that that doghouse gets a separate user fee charged? It doesn't make sense. The law is specifically clear as it relates to charging sewer fees. And we've paid $7,888 more than we should have. And we just want it back. And we want our changed sewer user fee set at 1. That's as simple as this is. The purpose of the code there is to allow for the billing of sewer user charges. And it's found in 2131. The authority is not in the definitions. And with that, I would beg that the commission consider our evidence, consider our cross-examination of the witnesses and their unfamiliarity with the code and what is supposed to happen, and find in favor of Kiowa Partners and return the monies and change the sewer fee. Thank you very much, Chair and Commissioners.
Thank you very much for your closing statement. Appellee, make your closing argument.
Yes, thank you, Chair. Thank you, Commissioners, for your time today. This is not a case, this is not a garage or carport. In fact, there's a garage on the other property, but this is a building that has a shower, a toilet, a laundry facility, and could be used for a studio. It could be inhabited. And that's basically how this was interpreted by the director, by the inspector. This case is also about accountability. We all have a responsibility to review our bill thoroughly. We all have a responsibility to know. And I would also say that these are not your lay people that have one property. You know, they have multiple properties. You just heard him testify that he is a property manager of multiple properties that have one unit and multiple units. And therefore he had notice of how much one unit costs, right? They created an LLC. They even got this property registered as a historical property. And if anybody has worked with SHPE, they know that's not an easy task. They've reviewed bills for not just themselves, but other people. If they believe that there was a mistake made, they should have brought this up in 1998 or 2000 or any of the last 24 years that have passed. This case is also about discretion. The director has the authority and the discretion to decide and interpret the code. And that's what he did. He looked at the evidence available to him and he decided that this unit meets the definition of an unoccupied unit. It's connected to the sewer. It receives a water bill, even if it's an adjacent property. And it has plumbing fixtures. So in the end, there's been a lot of, talk of definitions and technicalities of, a storage building isn't contained and this and that and all the other thing. But the real issue that the commission is deciding today is, did the director violate the law? And I would say no. He looked at the code and went with the strict definition of the code. 2, was his decision clearly erroneous? Again, no, it was not clearly erroneous. It has substantial evidence to support it. And 3, was it an abuse of discretion? And again, the answer is no, it wasn't an abuse of his discretion. He acted within his authority. He looked at all the facts available to him and he made his decision. So I don't think that the appellant has met their burden today. I don't think that they've proved that there was a violation of law, that it was clearly erroneous or an abuse of discretion. Therefore, the only thing the commission can find today is that the director's decision should be affirmed. Thank you very much.
Thank you. Now we move to commission discussion and deliberation. I would like Commissioner, maybe I'll tap Vice Chair Rick Gaffney, if you would, to make a motion on whether or not we should affirm the decision of the Director of the Department of Environmental Management, or whether we should reverse, modify, or remand the Director's decision. Can I get that motion? Or pick a motion? Which action do you want to take?
I would like to make a motion that we modify the director's decision.
Within the motion, do we need to say modify it to what, or just modify it?
Just say modify, but it needs a second.
I second, please.
And D is second, D Fulton seconds. So now we do discussion. I'll reiterate a little bit of what has been said by our attorneys. According to EMC Rule 713, the standard of appeal, the decision appealed from may be reversed or modified, and the motion is to modify only if the commission finds that the decision is 1, in violation of the code or other applicable law, 2, clearly erroneous in view of the reliable, probative, and substantial evidence on the whole record, or 3, arbitrary or capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion. We also have the opportunity, if you wish, to go into executive session with our corporate counsel upon a majority vote, I think, or we may need unanimous 5 of us voting to go into executive session, but we don't have to. Are we ready for an open discussion on the motion to modify? Okay, I guess I'd like to know what the motioners were thinking in terms of the modification.
I'll start because I was asked to make the motion. I think that there's 2 questions facing us here. One is whether or not the decision to charge 2 sewer fees for this property was correct. And then the second decision is whether or not the $7,888, I think was the figure, that was potentially overcharged based on that decision, should be returned to the appellant. So I personally would like to break the question of modification of the decision into those 2 pieces.
And then would you explain to us which one, what decision you would make on both of those?
Yeah, well, I'm not sure about the secondary one, and I do want to ask our attorney quick question. The legal definition of arbitrary, I think I know what arbitrary and capricious means, but I'd like to hear the legal definition of arbitrary and capricious before we proceed with that question.
Sure, I can give a general definition. So a decision is arbitrary or capricious if the decision does not articulate a rational connection between the facts found and the conclusions made. That's generally what it is.
Okay.
Dee Fulton, comment?
Yes, thank you, Georgine. I think it's important to note, and I want to confirm this with our counsel, that we are given 3 items, and it appears that if any one of these items is applicable, then we should modify or reverse it. So there are ors between those things. It's not a combination, the way I'm reading it.
That's correct.
So
Yeah.
the decision is in violation of the code or applicable law, or clearly erroneous in view of the evidence, or arbitrary or capricious. Any one of those 3 are grounds for reversing or modifying.
That's correct. Any one of those 3 or even a combination thereof.
Thank you.
Did you have an opinion on which way to go and why?
Well, to continue, I think I'd stop. I don't have to think beyond the second one, clearly erroneous. It's pretty clear that an error was made in assessing a fee on the unoccupied unit. I think it's very clear that the unoccupied unit is not a residential unit, addressed in our off-quoted Rule 21-31. So I think a mistake was made, and did the inspector make the mistake? Was there a clerical mistake? I don't know, but it very clearly looks like an error. And it looks unjust. As Mr. Henderson pointed out, he's paying more than his fair share. Simply put, more than his fair share. I don't think that the argument that this was ignored for 20 some years is relevant. It's a matter of, for me, it's a matter of justice. Thank you.
Other comments, discussion from other commissioners? John or Lee? Lee McIntosh, you're muted.
Okay, I shouldn't be muted now.
All right, good.
This is Commissioner McIntosh. This is kind of confusing, all the, the definitions and everything that they were putting out and trying to, from what I understand, laws complement each other. They don't have to necessarily all be contained in one point, a spot. Then you also have layers, county, state, federal. But from what I can see in the closing argument of the appellant, according to what he's saying for the storage building that he's calling it, technically he wouldn't have to pay a sewer bill, period, because that property doesn't have a water meter. It's the property next to it. Although, for whatever reason, so I understand now why the DEM just says in the rules that it has to receive a water bill, or in their case, they open the tap and water comes out. That means that that they are paying a water bill and they have sewer fixtures. So my reading and understanding that it is that this building would be indeed considered an unoccupied unit, because it doesn't necessarily say that someone has to be able to live in it. It just needs to, let's see here. It just has to, let's see, have accessibility to the sewer, have the plumbing fixtures, and then, it receives a water bill. So it has water from the county coming in. And it meets those requirements. Doesn't say someone has to be able to live there. It has to have a bed. That doesn't matter. And the other thing is that, by law, we couldn't return all the money if we wanted to, refund it, because as our lawyer has stated, they can only seek up to maybe 2 years back pay. So I was, that just brought up concern, why they wanted the whole amount. But anyways, I would, me personally, I would have to, wading through all this information, I would have to say that I would support the director's decision based on what has been presented and all the evidence and stuff. And, whatever I feel personally about it doesn't matter. I have to decide based on the evidence, and that would be my decision.
Thank you, Commissioner McIntosh. Commissioner Burns, do you have comment?
Yeah, I mean, I concur with what Lee just stated. I mean, just going off the evidence of what I read through all the papers we were given, I don't see anything presented that shows anything to really clearly show that there shouldn't have been that designation, considering that as far as I can see, the unit as in that property is receiving water, and then you have a dwelling with fixtures that are draining to the sewer. So yeah, I can't see, it's just not clear to me that there was a blatant mistake made and that there should be anything to overturn it, the decision.
Thank you. I'll put in my 2 cents, Georgine Adams. I too feel that the interpretation and application of the 2 units is a reasonable interpretation and within the discretion of the department. It is a long time interpretation of the requirements that you got a toilet in there. And it can be used, whether it is used or not, it is hooked up to the sewer. So I think it is a reasonable application. And as I understand it, the department has offered the solution is don't have those facilities in that storage room. So I too would affirm the director's decision. And insofar as Rick was talking about splitting the two, the fact that traditionally sewer engineers consider a Y connection to be a separate connection to the sewer is a legitimate one. If it had run straight into the house and then it was the house going to the lateral, I could see an argument for why it's not a separate unit. And the fact that the charges have been there for umpty-ump years is also not a compelling argument in my mind. So that would be my decision to affirm as well. We appear not to have consensus. I don't know if we want to take a vote, a roll call vote.
I think, sorry, Chair, if I may. I believe Commissioner Gaffney wanted to say something, and then Commissioner Fulton.
Okay,
she also
yeah, I
has a
just saw
follow-up.
Dee's hand. Sorry. Rick, you had more comment.
Yeah, well, the one other comment that I would make with regard to this case, and I'll probably make this in the future at Environmental Management Commission meetings. One of my big takeaways from reading all of the documents that were provided to us in this case is that the county laws are really, really poorly written. And part of the reason for my belief that the decision the director made is erroneous is that the county also shows that they have been picking and choosing the language from various parts of the county code that they use to support their case without looking at what's logical. And clearly, logic was not part of the writing of the ordinances original, or the rules originally, because in my mind, this is clearly a single family dwelling. And per that part of the definitions, I believe that it's erroneous to charge them for 2 sewer fees when it's clearly a single family residence. The fact that at some point in time, it could be converted, the second building could conceivably be converted into some kind of a dwelling, doesn't recognize what it is, which is an outbuilding, a reclaimed outbuilding. So anyway, that's my take. I think that the language of the county, both with regard to this particular question and also with regard to possible reimbursement, is sorely lacking and needs to be fixed. So that's the only other point I would want to make. But I stand by my opinion that I share with Commissioner Fulton, which is that the decision by the director was erroneous because, in my mind, based on reading everything and hearing the testimony today, this is clearly a single family residence, and I don't believe that it's correct for it to be charged for 2 sewer fees, particularly when it only has a single water source, and it's not used for the 2 buildings on the property are not used as multiple occupied, under the definitions in the ordinances, dwellings.
Dee, did you want Dee Fulton comment?
Yes, thank you, Chair Georgine. A number of points. I want to start out by saying, if somebody has an ohana in their home and it is rent it out to a whole separate family, but it shares the plumbing. What is this? I don't really know the answer, so maybe I shouldn't ask the question. I'm not being a good attorney here, but wouldn't they just get one sewer bill if there's one meter, one water meter? No, I see head shaking. Okay. I want to go back to the beginning of this structure. It was designated a historical structure. And in order to preserve that designation, I think the architect was limited. And so while additional facilities were needed, they couldn't fit within the footprint of that historical structure. Thus, the necessity in creating a separate outbuilding to house facilities that typically would have been within the confines of the original building. So that's one point, is that basically you have an extension of a single family dwelling. Secondly, with all due respect, Chair, the shape of the plumbing, whether it's a Y or a T, achieves the same effect. So I think that's a kind of a silly thing to be using as a rationale. Apologize there, but really, I don't want Mr. Henderson to have to go and dig up the plumbing and change it so that the sewage line is from that, from the outbuilding is connected to the residence. That could be done. Okay, but it's going to have the same outcome, right? The same stuff goes into the same pipe at the same point. Okay. So I guess I feel very strongly sympathetic to Mr. Henderson and the situation we have. And oh, this is one more point. And that is back to this wonderful rule. The point about the definition of an occupied unit, which was the primary rationale, I believe, for why this Mr. Henderson was getting a second billing. An occupied unit means a unit that is not occupied, but has accessibility to a sewer plumbing fixtures located on it and currently receives a water bill. That unit separately does not receive its own separate water bill. They are combined. There is one water bill because that outbuilding is simply an extension of a single family residence. I think that's all I have to say for right now. Thank you.
Thank you, Dee. John Burns.
Yeah, I was just gonna weigh in, and I mean, I don't disagree with what Rick and Dee are talking about in the assessment of the logic of it being a single dwelling. But I do think that our task for this specific case is to judge that designation that was made. So each time a designation is made in regards to a unit being an additional dwelling or not, you know, there's a lot that you could argue, right? I mean, on any property, if you decided to make a second unit and you decide to plumb it and you decide to have wastewater and you permit it, a designation is going to be made. In this case, though, the designation has been made. So I just don't know if it's appropriate to argue the logic of that designation so much as the fact that it was made. There are those plumbing fixtures there. Whether or not it's used as a dwelling isn't irrelevant to that designation. And so I think if we just look at it specifically in the context of that and whether or not it should be overturned, that's where I don't think I can see anything, at least in what's been presented, that there's hard evidence to say that that designation is erroneous or should never have been made, right? Like at that time, it seemed reasonable. There were the fixtures. It is having existing plumbing that drains out. It's just like if I made an Ohana unit and I wanted to argue that it shouldn't be a second dwelling, at some point, if a designation is made, that's what I have to go with. So I just don't know how productive it'll be to argue the logic of what was made versus whether or not there's something to say it should be overturned. And I can't see anything to show that. So anyway, that's just to clarify my thoughts on it.
And I would agree, this is Georgine Adams, I would agree with Commissioner Burns that it's reasonable given the construction, the fact that we do charge for unoccupied buildings, and it's basically the fact that you're generating wastewater or have the potential for wastewater, and the county has to maintain the connection and treat the waste that come through it. And Lee, did you have any other comments?
No,
Lee McIntosh?
just that, the reason I said what I felt personally didn't matter is because I didn't want to muddle everything. But since everybody's sharing, then, I don't necessarily agree with the designation. To me, one TMK should receive a sewer bill, and that should be it. And, that based on water usage. But, that's not what we're here to decide. We're here to decide about the decision the director made. And, it makes sense to me. But I guess my only concern is that the motion was to split it into two. And I really don't see, I'm kind of confused how we're going to proceed. Because
If I may, I can help.
Go ahead.
I think the motion was to modify the director's decision on appeal. Commissioner Gaffney, in his explaining of his position on the motion, in his thought process, and you can correct me if I'm wrong, Mr. Gaffney, was he separated sort of two issues with respect to how he analyzed it. So that wasn't a part of the motion. The motion is still to modify the director's decision.
Oh, I see. So we just are modifying it. We're not ruling in favor or against.
So that was just the motion. So ultimately the result is how you vote on it, right? So if you agree to modify the decision, you would vote for that. If you disagree, you would vote against that. So it doesn't necessarily matter what the motion is. It depends on how you vote in the end.
Okay. Do we have to designate specifically how we're going to modify it before we vote on it? Or will that come after we decide to vote to modify it?
So I would say, to make it easier, it sounds like there's not enough votes to carry the motion. But for formality purposes, I would ask Peter to do a roll call vote on the motion to reverse, or excuse me, on the motion to modify the director's decision. And if it doesn't pass, then someone can propose another motion. There is a commission rule that if you need 4 votes today, either way, for the motion or against the motion. If there are not 4 votes, then the chairperson has the discretion to continue it to the next meeting, where we will have other commissioners who will then have the responsibility prior to attending that meeting to go through the record, read the transcript, go through the evidence and hear everything, essentially catch up to what was heard today. And they would have an opportunity at that meeting to be a part of voting on the motion, whatever motion that is at that time. But in order to get there, the motion basically, it has to be fewer than 4 votes. And I don't know if, is that confusing?
I think it made sense.
Okay.
I got it.
So of the commissioners who are here, we're going to take a vote. We'll ask Peter, sir, our secretary, to take a roll call vote. And if we do not have, and you say 4, a majority, well, it's a super majority, 2/3 of the votes to modify, then we will need to take this up again at our January 26th, I think, meeting, and include the opinions and votes of other commissioners. Did I say that right?
That's correct. And just for everyone's information, this is EMC Rule 7-12, where it states a decision appealed may only be reversed, modified, or remanded upon 5 affirmative votes of the commission. If fewer than 7 members of the commission vote upon an appeal and there are fewer than 4 affirmative votes to reverse, modify, or remand the decision appealed, the chairperson may defer the petition until a future meeting of the commission for a second and final vote to be taken on the appeal.
And we would not be collecting any more additional information, it'd just be on the record that we've already created.
Right. So essentially what would happen if that's the case is the other commissioners not present here, but who will be involved at the next meeting, they will have to affirm on the record that they've reviewed the transcript or watched the recording, reviewed all the evidence, and they can attest that they are they can participate in the vote of the motion at that time. But we would not be taking on additional evidence. I mean, I suppose if the commissioner who is not present today has questions later on, we might consider reopening the evidentiary portion just so that they might ask clarifying questions of the parties. And I think that's fair for both parties and also fair for the commissioners who are not present today. So we can take a look at, if it gets to that point, reopening just for the purposes of them to ask their questions or get clarification.
Okay, well, Peter, why don't you move on then to doing a roll call vote on the motion to modify the director's decision.
Kira, I have a question. If this motion passes, do we continue discussion as to what the modification would be? If it has 5 votes or 4?
Yeah, we would, because we would have to say, so I guess if I was trying to make it easier, but maybe that's not, if that's not easy. If Commissioners Gaffney and Fulton, if you would so put on the record to what you would propose modifying the decision to be. I think that would make it easier and all encompassing of the motion.
Well, I did say earlier that I wanted this discussion to be split into the 2 parts. One was whether or not the decision was erroneous, and then secondarily to talk about the question about reimbursement, because I think that's a separate issue that is defined separately in the law and needs to be considered separately for that reason. So the first question is modification, and what I would propose as a modification would be that the original erroneous decision to charge for 2 dwellings, effectively 2 occupied dwellings, be reversed, so that in the future, Kyola Partners is only billed as a single residence. So that would be the modification that I would propose.
So is there, are you basically are changing or withdrawing your original motion and substituting this one that says to?
No, I am not substituting a new motion. I am just refining. The question that was asked by Corporation Counsel was, what was the modification that I would
The
propose?
dog and pony show now.
So that's what I have. That's what I just stated, is that's the modification that I would propose if we voted to modify.
Okay, sounds like we're gonna work on 2 separate motions. First one, do we have enough votes to modify? And the second will be a more specific motion on what that modification should be if it passes.
That's correct.
Okay, let's do the first motion then, which would be to modify the director's decision.
Commissioner Burns,
Yes.
Commissioner Fulton,
So I want to back up.
Wait, sorry, are we voting?
Yeah, we're
I thought you
voting on whether or not to modify the director's decision.
Okay, no, I vote nay.
Commissioner Burns votes nay. Commissioner Fulton,
I vote in support of the motion.
aye for Vice Chair Gaffney,
I vote in support of the motion.
Commissioner McIntosh,
Nay.
Chair Adams.
Nay.
Chair, you have 2 aye votes, 3 opposed.
So as I understand it, what we'll need to do then is go to another meeting. Hopefully the next meeting of the Environmental Management Commission. I don't know if we should try and see if we could get yet another meeting before that.
When is the next meeting, Peter?
The 26th, I think.
26 is our next regular meeting.
I think that's fine if we plan for the 26th.
And then we'll get the larger commission members, hopefully, to weigh in. And if they have clarification questions, I don't know if it's something that we need to make sure that the Hendersons can attend, or if we could get those questions in writing to them.
Yeah, I guess we could ask the parties now. Mr. Henderson, are you and your father available? What is it, January 26th
Correct.
at 9 a.m.?
Hold on and let us check our schedules. I'm open. So we're both open for the 26th of January, a Wednesday,
Thank you.
9 a.m.
Thank you. Ms. Kikai.
I'm also available, thank you.
And also, can you see if your witnesses, or I guess Director Mansour, are you available at that time?
I believe so. I'm gonna be driving to Gila, but yes, I'll be available. I'll
Okay.
try to choose my phone.
Thank you. Ms. Nakatani?
I will be available on the 26th at 9 o'clock.
Thank you. And Ms. Bauman?
She's still on the line.
Yeah, you're on mute, Robin, if you're trying to talk. Or at any rate, I guess we can ask Mr. Kai to follow up with Ms. Bauman to, just in case the other commissioners have questions of the witnesses at the next meeting.
And that meeting is going to be a Zoom as well, so people can call in. And Ramsey, I guess you could tell us when you're going to be safely set so that you can participate in the meeting.
Chair, after 10 would be good because he has a brief appointment in the morning on the Kona side. He has to drive over.
Okay, so tentatively, considering.
If I can help,
Sure.
since the regular commission meeting starts at 9, we can put this on the agenda at the end. And if we happen to finish before 10 o'clock, then we'll wait until the director is available at 10. So I guess for the party's purposes, if you folks can just make sure to appear at 10 a.m. on the 26th.
I can almost guarantee our meeting will go beyond 10 o'clock for a regular EMC meeting. So that won't be an issue. Okay, so just FYI for the future, what we still need to do then is to get a vote and see whether or not we are affirming or reversing, modifying, etc. The decision of the director. And then after that decision, if it is to make, well, I guess it doesn't matter, whatever our decision is, there's a proposed findings of fact, conclusions of law, decision in order that the prevailing party prepares, and then a series of timeframes to write that up, get comments on it, and then the EMC as a whole would adopt that finding for the record. Is that right? Got that? Okay.
Yeah, that's correct.
So I think we're at the point of adjourning this hearing and continuing it to January 26th, 10 o'clock. And we will send out notices for when and where to connect, so that we do this again and to get the full package to the other commissioners. Do I just declare adjournment, or do we need motion?
You can do a motion to adjourn, because we're gonna re-agendize it at the regular meeting. So it's not gonna be considered a special meeting. It'll be on the regular agenda.
So
I
moved.
think Ms. Commissioner Fulton has she made the motion. Thank you.
She made the motion to have a second.
Second.
And Rick to adjourn. And then we're not supposed to talk to each other about or do additional research or any of that stuff about this particular contested case hearing, correct?
Correct.
Until the next
Thank you.
26th meeting. Just
Correct.
try and make sure I've got it all straight.
Okay, thank you.
I thank you, everyone, for attending and for voicing your opinions, and we'll see what we can do next time.
Thank you, Chair Adams and commissioners.
Thank you. I think Commissioner McIntosh was.
Peter is asking for the vote.
Oh, thank you for being in the room and catching. Yes, we need to vote on the motion to adjourn. All in favor, say aye.
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 Aye. Anybody opposed? No, we are adjourned as of whatever time it is.